What is the difference between healthcare power of attorney and a conservator? Imagine you're planning for the future, making sure your wishes are known. Sometimes, things don't go as planned, and questions come up about who makes decisions for you. Today, we're going to clarify two important roles that can help in these situations. A healthcare power of attorney is a legal document you create while you're healthy. It lets you choose someone you trust to make medical decisions for you if you become unable to do so. This person, called your agent or proxy, can decide on treatments, medications, or end-of-life care based on your wishes. The document only activates when you are incapacitated and cannot communicate your preferences. It's a way to stay in control of your health care, even if you're unable to speak for yourself. A conservator is someone appointed by a court after you are found legally unable to manage your own affairs. This person can handle your financial matters, personal needs, and sometimes healthcare decisions. Unlike a healthcare power of attorney, a conservator's appointment involves court proceedings. The court supervises their actions and can requiring regular reports. The conservator's authority is broader and usually more formal, covering many aspects of your life depending on what the court orders. The main difference is how they are created and who appoints them. A healthcare power of attorney is a private agreement made by you before any incapacity happens. It does not need court approval and is based on your trust in the agent you choose. A conservator, however, is appointed by a judge after a legal process, often when no prior plan exists or when there are disputes. Another key difference is scope. A healthcare power of attorney focuses only on medical decisions. A conservator can handle healthcare, but also your money, property, and personal care. The activation of a healthcare power of attorney depends on your incapacity, but it is effective immediately once signed and your agent is designated. A conservatorship begins only after the court appoints someone, which can take time and involves legal procedures. In terms of oversight, a healthcare power of attorney is a private arrangement. You trust your agent to act in your best interest. With a conservator, the court keeps a close eye on their actions, requiring reports and approval for major decisions. Using a healthcare power of attorney is often preferred because it respects your wishes and keeps things simple. It allows you to choose someone you trust in advance, avoiding court involvement. Conservatorship is usually a last resort, used when no plan exists or when there are concerns about the person's ability to manage their affairs. To prepare for the future, it's wise to create a healthcare power of attorney early. Talk with your chosen agent about your medical preferences and make sure your documents are up to date. If no plan is in place and you become incapacitated, family members or others might need to go to court for conservatorship, which can be costly and time-consuming. In summary, a healthcare power of attorney is a private, proactive way to handle medical decisions, while a conservator is a court-appointed guardian with broader authority, activated only after legal proceedings. Both play important roles in elder law and estate planning, but planning ahead with a healthcare power of attorney can often make things easier for everyone involved.